court, presided over by Justice Gifty Ejay Ado in her judgment, noted that the rights to education and to freedom of religion cannot be replaced by ordinary subsidiary rules and described as unconvincing the arguments by the Achimota School Board of Governors. Ras Wayo is member of the legal team of the two Rastafarian students.
What her ladyship said is that rights as guaranteed under the 1992 Constitution is not absolute. They can be limited, and it was not in contention. But the crux of the matter is, at what point do you limit these rights? And the law is clear. There should be compelling reasons to limit these rights, and it must be bordered on public interests, and then not trampling on the rights of the other person. Now, if Achimota indicates that you must have your hair low, and therefore a young chap with a dreadlock is to come to Achimota and has a dreadlock, how will that impede the community of students in Achimota School? How will that hurt their interests? How will that hurt the administration of the school? Under Article 23, that public officials, when they are administering their work, should do that to achieve a just and a fair society, to be candid, you understand? So in totality, her argument is that you need to convince me the compelling reasons upon which you are limiting their rights.
Achimota School in March this year refused to admit the two students, Tyrone Iras Magai and Ohiniba Kweku in Krabia, due to their dreadlocks after they had been placed in the school by the computer school selection and placement system. It was, however, a post made on Facebook by one of the fathers that made the case a national issue after it went viral. Not even a directive by the Ghana Education Service could get the school to rescind its decision. Today's ruling by the Accra High Court is, however, an order that must be obeyed. The Attorney General's Department argued in court without success that schools under the GES cannot be sued, but the court still ordered Achimota School Board of Governors to file their response to the suit. The Attorney General also raised a preliminary legal objection to the capacity of Iras Magai to initiate the action of the suing parties. Mr. Dame, who moved an application on the capacity of the plaintiff, said the applicant could not institute such an action against the school in the first place.
And that's how it all went down yesterday with that landmark ruling. Let's have a conversation on the back of that. Rights Appear's Executive Director, Child Rights International, Peter Nti's Executive Director, Institute for Education Studies, Kofi Asare is Executive Director, Africa Education Watch. Good morning to you, gentlemen. Thank you for your time this morning.
Good morning.
Mr. Bright Appear, you had something to do with this case. So let me get a quick reaction from you with regards to yesterday's ruling.
Oh, well, for me, it's a victory for every child in Ghana. And it's also a victory for Ghana Education Service. And thing that's been made clear, and we need to also acknowledge. And let me use this platform to appreciate the lawyers who really handled the case for Tyrone. That is James, and those who are working behind the scene. That is Francis Ontoyi. They've done a very good job, the research work that they've done, and for us to come to this conclusion. I think that is victory for all of us.
Is it really victory, Kofi Asare? Is that what you see from where you sit?
Sure, I think it's a victory for the right to education and a victory for the rule of law and a victory for inclusion. In any civilized society, when citizens feel that their rights are being trampled upon, the last resort is to go to the courts to seek an enforcement of those rights. And so a citizen felt that his rights was being constricted by an administrative decision, and all efforts to have the institutions resolve the matter, yielded no result. And so going to court to seek an enforcement of their rights, which at the end of the day inures to the benefit of the Republic, because it supports government efforts towards achieving universal secondary education for all children by 2030. And so obviously the GES should be happy, Ghana should be happy, our schools should be happy because we have a ruling that puts into proper context the issues relating to the premium that school rules should enjoy when it comes to legal and constitutional issues, and also how our school rules should be administered, consistent with existing laws and the Constitution. And so it's a victory for all of us. There's much clarity in respect of the place religious rights play in enforcing one's rights to education.
Okay, Peter, let me get a reaction from you as well.
Well, I think that this puts to rest the recurrent nature of decisions by school authorities in determining who gets access to their schools and who is denied. I think we have had issues coming up now and then with this kind of challenge. So it's good that we are having this decision from the court, and until it's overturned, we are hoping that our schools would now not discriminate or would now not deny people access to education based on this particular grounds. So for us, it's a progressive decision, and we are hoping that we'll be able to tie in with other policies to make it work more effectively in our schools.
Now, gentlemen, there's Angel Kabono, who is the president of NAHRATS, who was reacting to this ruling and essentially was saying that it opens the gateway for all sorts of hairdos and lifestyles in schools going forward. And perhaps they just have to concentrate on teaching students in the classroom and not be concerned about how they look physically. Is that the same interpretation that you get right up here?
Well, I when I heard him yesterday, the first thing that came to mind is whether he had seen the ruling from the court. If indeed he had, then I think that the language would have been different from the way he approached it. Because her ladyship was very emphatic on what the issues are. And I can say on authority that even the basis of the judgment is as a result of the power that the school environment holds when it comes to the regulations and the things that they have to do, vis-a-vis the issue of people practicing their religious belief in a context that conform to the rules and regulations. So she gave much, she emphasized more on the how school rules and regulations are very important. However, those rules must also be done in a manner that conforms to the constitutional provisions and all that. So that is the basis for her judgment. So if you say that it opens the floodgates, I'm a bit confused. Again, she was very specific to this particular context. So which suggests to me that violations of that nature must also go to court so that the balancing act will be done before you come to certain conclusions. And now most of the things that need to be done in our schools, which I find it as a very innovation from the court, is that they have given power to Ghana Education Service that whatever the school environment does henceforth should be by a regulation from Ghana Education Service. Therefore, whatever Ghana Education Service communicate to the schools, that is what the governing authorities must comply with. So she has done a very comprehensive work, and I would suggest to the unions that before they make any statement, I would suggest to them that they should have a look at the judgment and draw the strength from the statement made by her ladyship before they make any statement, because she was very, very strong and emphatic on the concept of school regulation and what the role that it needs to play within our educational system. But in doing that, the school environment must weigh the balancing act as to whether the practice of religion would have effect on somebody's right or it will undermine somebody's right and all that. All these were played out in the judgment. So I am even careful to come to the conclusion that this case settles all matters when it comes to religious beliefs in schools and all that. Because the way she passed the judgment, it means that specific issues relating to a conflict between school regulations and violation of human rights must always come to the court for interpretation. So these are things that for us we need to wait, and I don't think that she has opened the floodgates for anybody at all to think that at any material moment I can decide that this is my religion, therefore I need to practice it. But there were specific issues that she mentioned to the extent that she measured her judgment based on the litmus text that was enunciated by Adinyra GSA to establish the kind of judgment that she gave. So clearly, we have to be very careful for us to draw the conclusion that she said that we've opened the floodgate. For me, it is even scarier that we don't have absolute decision as to how people can even practice their religion. But when it comes to this specific case, she has stated her position and even made it clear that if Achimota School had proven beyond all reasonable doubt that the establishment of this rule is superior and it is for the benefit of all children, she would have ruled otherwise, So she laid down all the rules. So I would just again suggest that is to look at the judgment before they pass any comment in respect to what we are talking about today.
Kofi Asare, should this lead to a review of school regulations? Because I'm not sure that all the regulations will pass the test of human rights and whether or not it contravenes what's in the Constitution.
Well, before coming to that, let me just say this quick thing about the floodgates concept. There are two schools. The first school is people who genuinely have concerns about discipline in schools and believe that, there might be a floodgate being opened. I think those belonging to that school of thought do not have to worry that much, in the sense that anytime change becomes, that is how society receives change. 2 years ago, when the GNS was rolling out the positive discipline policy to replace corporal punishment, teacher union said that is the end of discipline in schools. People said so many things, that how can I teach without a cane? It's been past 2 years and teaching has been going on without canes. And so that is the nature of change and how human societies embrace change. The second school of thought are people who genuinely have sour grapes and who genuinely have, people who have misconceptions and all that about giving rights to Rasta people. But I believe that the law exists to take care. The law exists not just because of the majority, but democracy is actually a majority rule that takes care of the rights of minorities. You can't break the law to uphold the law, simply put it. And so the rules might be necessary, yes, but then it must be consistent with existing law. And that has been the experience in Malawi, in South Africa, in Zimbabwe, and Kenya. Floodgates have not been opened there. In Accra Academy, in Agri Memorial Senior High School, in Pope John Senior High School, floodgates have not been opened. There are Rasta students there. And so let's ground that genuine concern in what goes on in the schools, reputable schools in Ghana that have Rasta students. Having said that, I am informed that the National Peace Council was planning to outdoor and validated was planning to validate an MOU with the missions this week, I think by midweek. I think that process will have to be staggered because, as we mentioned earlier, that MOU has ramifications on the rules of conduct in mission schools. However, this ruling has ramifications on the rules of conduct in not only mission schools, but all schools. So it is important, in not only mission schools, but all schools. So it's important for the Peace Council to stagger that process, get a copy of the ruling, study it, and ensure that the ruling captures the spirit of the MOU being constructed or supposed to be validated and announced this week. Takes into cognizance the spirit of the ruling, so that we don't have to go back and forth with various court interpretations when it comes to adapting the code of conduct for not only mission schools, but then all our senior high schools.
Okay, before we come to the issue, the question that I ask in terms of whether or not we need to take a look at the regulations governing schools in general. Some people have said that the Achimota headmistress should take a bow now after this ruling. I don't know, what do you think? Maybe I should go to Peter Nti. I'll come back to you, Kofi Asare. Peter?
Well, I don't think we should go to that extent. I think that Achimota was doing what they felt was right, and in doing that, they decided to uphold their rules and regulations. Remember, their decision was backed by the governing board and the PTA, and I think the old students too. So there was a lot of support. And even the Ghana Education Service at a point in time supported the decision of Achimota. And of course, when the case went to court, the government supported the position of because maybe they were sued alongside, they supported the position of Achimota. So I don't think that we should stretch this thing that matter. I think that we should see this as the end to this particular issue and find ways to make sure that our school environment is conducive and accommodating enough for all kinds of students that we will have on our campuses. I would want to say further that the position by my senior brother and the NAGAT president is a little bit unfortunate. It's unfortunate because the teacher is trained to not only develop the cognitive ability of the student, he's trained to develop the skills too. He's trained to develop the affective domain, which means that the teacher is trained to make sure that he puts into the child the requisite behavioral outcomes that are fit for society. So this decision should not bar a teacher who has gone through a professional training to just restrict himself to the duty of teaching and then learning. But of course, they should continue to do what they think is right and help to develop the moral behavior of students to be able to enable them fit for the wider society.
But gentlemen, there are people who have said that this is the 21st century. It shouldn't take a court to you come up with a decision that a head of an institution can easily take. We've seen examples of other students with dreadlocks attend some other schools. And so if the Achimota School or the head had to wait for a high court to rule before admitting students who have this special case, and then she doesn't deserve to be there. I guess that's why the issue of her, moving out, particularly after this ruling, has come up strongly. I don't know what you make of that, right up here.
Yeah, well, I find it a bit difficult to place it in that context because if you look at the letter that was written by Ghana Education Service instructing its worker to abide by a certain rules, for that matter, to admit the children. And you also look at the decision of the governing authority, who derive their power from the minister, also reversing that authority to the extent that they even threaten Ghana Education Service that if they go ahead with that decision, they would also advise themselves. And they were able to get the association, which happens to be the employees of Ghana Education Service, would also back them. Then that also brings some issues of administrative order where, the assistants must also work in a manner that also respond to law. Because if you look at the case that her lordship handled, she also made it clear that administrative activities must also protect human rights. She made it clear. And then also established that, look, whatever you do in the school, it must be done in accordance with Ghana Education Service rules and regulations. So if we have had a past where Ghana Education Service, which is an authority to regulate the school environment, will issue a letter, and then other bodies will come in and say that they will not respect that directive, I think that this case has established that. But it's unfortunate that you would have a situation where all student associations, unions, and even governing authorities would have a certain posture against administrative authority that's supposed to issue instruction as to how they have to conduct themselves. So if we have experienced all these things in the past, for me, this issue comes to settle all these things so that now moving forward, the governing authorities, the associations must know their place. The old student association must know what exactly they have to do within the school environment and know that. It is so clear. Now we know that there's so much power that rests with the Minister of Education and then Ghana Education Service. So anytime that something is issued from their end, that is how we would treat it. But it's rather unfortunate that the headmistress must find herself between the one group and then also the authority that employed her to handle the school and all that. But whatever it is, I think that we will not go into, moving forward, I don't think we are going to have that situation where somebody will say somewhere and think that he or she is an old student, a member of the school, therefore whatever they say should stand. But now we know that whatever Ghana Education Service says is final, and that determines the way and manner they will run the school. And if there is anything at all that they do not find right, then they have to seek that, they have to also petition Ghana Education Service to seek for clarification or go to court to amend anything that Ghana Education Service does. But we know that now whatever Ghana Education Service says is what the schools must do so far as the right of children are concerned.
Right. Kofi, does this have implications on the ongoing or the raging, if you like, Wesley Girls fasting saga?
Of course it does. But let me quickly say that the GNAS, if we had strong institutions in this country, GNAS wouldn't have required a court order to perform its role. I mean, 546 is clear. GNAS has the right, they are the coordinator. They are the coordinator of secondary education, and they have the mandate to deliver secondary education. No school's name is mentioned in 546. That's the GNAS Act. No school's name is mentioned in the law. It is only the GNAS that had a mandate at law to deliver and coordinate secondary education. So the GNAS has all the powers, except that it is powerless for very strange reasons when it comes to enforcing directives, mostly relating to religion and the likes in secondary schools. But the GNAS is very, very, very powerful, clothed with all the power it needs, except that only the GNAS can explain why, when it comes to enforcing minority rights, it is powerless. But when it comes to sanctioning headmasters, it is very, very powerful. That is a matter for the GNAS. But again, if an institution has a certain posture towards certain groups, and has a certain emboldened posture when it comes to disciplining headmasters, then you wonder whether they will actually require a decision of the High Court to realize that they are powerful. I think it has more to do with, I mentioned earlier, and without any equivocation, it has more to do with certain beliefs of certain people in management or in leadership. You see, we have certain beliefs that sometimes conflict with our interpretation of the law. And that is what happened, because I strongly believe that the GNAS, the same GNAS that would ensure that the headmaster is punished when they are found to have breached a particular rule or misconducted themselves, suddenly becomes powerless when it comes to enforcing the rights of minorities. I don't think that, I think that there's more to it than just realizing that they are powerful. Having said that, let me address the issue you raised. Yes, it is true that it has an effect on Wesley girls, because the issue in court and the issue that was in court in all the other African countries, similar cases, was about the right to religion and how in providing the right to education, the right to religion must not be discriminated against, or an individual must not be constricted in their enjoyance or manifestation of mandatory religious practices in their right in assessing their right to education. And so the fasting is a mandatory religious practice under Islam. It's the same. It has a direct bearing on the Wesley girls issue. And that is why I advised that the Peace Council, which was ready to sign an MOU this week, will have to delay the process, because this ruling will have a direct impact on the content of that MOU and the consensus that will have to be built with not only the faith-based organizations, but all of the institutions. You remember very well that when the GNAS announced, when the ministry announced that the Peace Council is having a process to engage the faith-based organizations and come out with a code of conduct or an MOU on how to govern their schools and the code of conduct conducive to their faith-based organizations, we raised an issue that the issue is not about faith-based organizations. It's not about missions and their schools. The issue is about the code of conduct in all public senior high schools, mission or non-mission. And so if you are developing a standardized code, it should be a standardized code for all schools, whether it's Benkum Senior High School, which is non-mission, or whether it's Achimota, which is non-mission, or whether it is Wesley Girls, which is mission. Other than that, we'll solve the problem halfway and come back and fix another another problem. This ruling has told us that, yes, the issue is not necessarily about mission schools, because Achimota is not a mission school. The issue is an issue for all public senior high schools. And so the Peace Council will have to be expansive in their approach and then actually look at the code of conduct for all schools, which actually also respects the ruling of this court.
Okay, there's an interesting place you've taken us right now. I want us to remain here. Let me say good morning and welcome to the conversation, Mr. Martin Pebble. He's a lawyer. His take on actions such as what we saw on behalf of the citizens of Ghana. Mr. Martin Pebble, the issue of ownership of the schools. I mean, if I'm a mission school, there's a reason the school is set up. And if you're going to use human rights and regulations that you say conflict with either the Constitution or a person's human right, then we will certainly have a difficulty, right?
Yes, Mama.
Yes, Mr. Pebble, I don't know if you got the scenario.
Yes. So, I mean, the Constitution is there and it's supposed to be used everywhere in this country. So there cannot be a law that the Constitution is not applicable in a mission school. No. You see, the Constitution is the highest law of the country. And so in every nook and cranny of this country, it prevails. And I think that it's good that, well, Achimota had a doubt. They thought that, no, the constitutional provision doesn't prevail. But the court has ruled otherwise. And so I think it's a good day for the rule of law.
It's just the impact that this decision will have or has on the raging at Wesley Girls School that we're thinking about and talking about right now. And that's where I am trying to draw a line. Are we saying that we can't draw a line, there's no distinction? The fact that I'm a mission school doesn't matter? The purpose for which the schools are set up doesn't matter here?
That's correct. That's correct. Because, look, you see, as long as the student qualifies, okay, all right, and then has been admitted, you cannot use a religious reason to stop the student. So let's say the criteria is being published, okay, for access to the school. So if the student, okay, I see what you mean, that if you say it's a mission school, meaning you want to admit only Christians, is that so?
No. I'm just, trying to look at, so if I'm a mission school, don't I have right to have my own regulations? Because remember that the purpose for which I set up the school really is to impart a certain knowledge into young people. I mean, we've made it public because it's a collaboration now between government and the missions.
Good. So as long as it remains public, all these things cannot come in. So you see that the earlier question, when I asked you that, okay, is it like you set up the school purposely to educate people only of a certain stage? So then, if it's that one, it's a different kettle of fish. If you say you want to educate people only of a certain stage, so others are not welcome, and then as a school, that school will not take a dime from or let's say a peswa from the government. Yes, then that one they should be allowed to have its own rules. But as long as the school is partly funded by the government from the consolidated fund, the constitutional provisions apply.
Mr. Pebble, stay with me. Peter, do you foresee, because I'm thinking that we will probably get to a point where the missions would say, okay, then we're taking control of our schools. Take your collaboration.
Mm-hmm. This is a difficult question. I think that it's not going to get to that extent. I believe that the missions appreciate that they are part of a system, and therefore they might have concerns and issues, but so far as we are able to integrate their concerns and issues within our broader policy framework, they need to accept that. I also have to state that what we need to do more importantly is to ensure that we continuously engage all relevant stakeholders in some of these discussions and make sure that these people, or there's a level of agreement across board before a final policy or whatever it is that we would want to put across or push across is adopted. I think that is the way to go. So if everybody is on board, we have had extensive discussions about the issues, and finally we agree that this is the way to go. Because, as I said, this ruling is progressive. I had a discussion with Lawyer Martin before this, and he told me that we don't need to go to court because the issues are clear, and truly that is what has happened. So I think that we are in a society, a more developed society now, that some of these things we need to reorient ourselves and appreciate the changing dynamics in our society and ensure that the basic principles and practices that we hold in high esteem are upheld whilst we are accommodating the others too that we think that needs to be come on board. Because the Constitution is clear that you cannot deny someone's right to education based on religious grounds. So we needed to have had a way to have solved this without going to this extent. And I don't think the mission schools, the missions would want to take that extreme position and say that they would want to take back their schools. I think that would be a situation which would end in the Supreme Court, and they might, I don't know, they pronounce on it, but I don't think we will ever get there.
Right, Tapia, you keep doing right, and talking about the Constitution, but there's also ownership, there's also responsibility, and there's an objective for such schools.
Yeah.
If they say they're taking their schools, can we survive?
Well, we've given them that opportunity before. You remember during Matthew's time, Honorable Matthew, Napo, as they call him, that they gave the mission schools a window that those who want to own their school and run it should step forward so that the system will give them the opportunity to run their schools. And when the criteria were given to them, none of them said they want to run the school by themselves. So clearly, on the basis of that, there's a clear acknowledgement that government needs to play a role in the management of schools. For that matter, it is the taxpayers' money that will be used to run it. And once you veered into that, then the school environment is purely described as a secular environment. Therefore, activities in the environment is only regulated by authorities that have been given to a particular institution to do that. So now it is no longer an issue of a mission deciding on what they want, but it is a decision of Ghana Education Service to tell them what exactly must prevail. And of course, in terms of administrative structures, their participation in the process would matter. But it does not mean that what they say or what they want is what must apply in the environment. But things that must conform to rules and regulations is what we need to promote. So, and you see, the history of these mission schools is also established that clearly we cannot just also conclude that based on history, that the intention of the establishment of schools by the missionaries were based on the fact that they want to have ownership of those schools. It will serve a purpose. And if you look at most of the missions, once a school is established in the past, sometimes they hand the school over to the community for the purposes of training children in that environment. So the intention behind this is not an issue of ownership, but to serve social issues and all that. And that is the kind of approach that we need to give to the way and manner we want to handle the school environment. So let's be clear on these things. It's not an issue of sometimes when people say right, then you paint the picture as if it is against all odds or anything that must be done in the environment. But it is a right that must also be promoted by the administrative structures. So you set rules that pertains to every environment. And for me, this comes to settle or bring out a strong issue that Ghana Education Service has failed in the past to do. That is how to regulate the school environment. So these are things that we need to. But if anyone, and I don't even think that government must even open a window for any missions to say that they want to have their school. And I always give Ahmadiyya Secondary School as an example. When you go to that school, you see all kinds of religious practices in that environment, but you don't see any conflict emanating from that place. So why is it that other schools can also conform to some of these rules and regulations and all that? So clearly, I think that this matter speaks to a lot of issues that we need to, Ghana Service must sit down and then look into their books and come out with the rules and regulations that must govern the environment.
Okay.
But they must always take into consideration that the best interest of the child should be paramount in any decision that they take in respect to those rules and regulations. Okay,
just a few legal hurdles. Martin Pebble, so Achimota School has the right to appeal the decision, or if you like, the AG. In the meantime, the students can go back to school, but there's the concern of possible hostility, because if you've been on the other side of me in the court battle and you're now coming to my school, should we be concerned that, you know, anything like that can come up strongly?
Oh, definitely. I mean, human as we are, it's possible that some persons in Achimota will not be happy, and so they will give animosity. But, you know, at this stage, we will appeal to them as rightly to look at the best interest of the child, okay? And not to take it out on the children. Sorry, they are two now, right? Yeah, so that's all we appeal to Achimota to do. And in natural fact, look, it's worth repeating that these are not the first children with dreadlocks to be admitted into Achimota. No, far from it. You know, Achimota has this rich culture of diversity where they admitted children with Rasta, that's children with dreadlocks, including even white girls, okay? And we've seen all the pictures. So for me, I always say that this court decision is just strengthening the hands of Achimota to continue with their culture of diversity, non-discrimination. Okay, so it's a good decision. So for the few that will give animosity, we pray that they should resist and that they should look at the best interest of the children. So now, you started on the question of appeal. So, you know, under the law, just for education, but I hope the Attorney General doesn't. The Attorney General can appeal, yes. And as part of the appeal, the Attorney General can apply for stay of execution, meaning that the children should not be admitted because the appeal will be ongoing. Yeah, it's a very high threshold to cross. So if they were to apply and then they succeed in getting a stay of execution, yes, the children can be kept out of the school until the appeal is heard. But as we are all sorted, I'm sure the Attorney General himself, being a young man, it's not likely to embark on such a course.
Does this mean that any Rastafarian, any child with dreadlocks, can go to a school, any school?
Yes, if the child qualifies. And as you earlier on pointed out, if the child qualifies, and then, so when I say qualifies, all the criteria, yes, so from this decision, it will not be wise for the school to turn away the child. And I don't even see how GS will sit down again to suffer such a bloody no. No. Now the court is spoken, it's very clear. So if any school were to attempt to exclude a child on the basis of the dreadlock, which is for a religious purpose, please, and let's repeat, now that we're doing education, the dreadlock on religious grounds, then in that case, the school will be wrong, and so have to admit the child.
Okay.
But if the child is wearing dreadlocks for fashion or expression, self-expression, no.
So let me just stretch this a little bit. Can I have a permed hair based on religious grounds?
Can you have
a permed hair based on religious grounds?
So far as I'm aware, there's no religion. There's no religion that promotes a permed hair. So until we see evidence of it, so let's not forget that this Rastafarianism has been accepted as a religion. So if somebody stands tomorrow that his religion or her religion promote STEM hair, well, we'll have to look into the book and see how authentic it is. Let's not just say that people will come up with all manner of excuses to have dreadlocks. No. Let's remember, apart from Achimota, Accra Academy also had this young man who also had dreadlocks. So after he left, how many children have since turned up at Accra Academy with dreadlocks? So I think that we shouldn't encourage some of the extensions and extrapolations. No, just let's take it one day at a time.
All right, Martin Pable, thank you very much for your time. Kofi Asare, I just wanted, in wrapping up this conversation with you in terms of the kind of atmosphere that will be created at Achimota School, would it have been a better option, even after the court ruling, for the parents to say, because of all the back and forth, let's just find another school?
Yesterday, I was on a panel with the GES Deputy Director General, and he mentioned that as part of their mandate, they will ensure that their staff in Achimota would not act in a manner that discriminates against the children when they get the ruling and then they comply with the ruling. And so their job is to ensure that the ruling is implemented, not anyhow, but then in good faith. So I think that I will rely on the promise of Dr. Tano and expect that there won't be any animosity which will not go unreported. Any staff of the GES who would openly express or exhibit such animosity will have to be dealt with in accordance with law. And I do not expect that to happen because Achimota in itself believes in inclusion. Having said that, let me quickly add that this matter shouldn't have gone to court. This is the 9th judgment I'm seeing in Africa in the past 5 years. This matter should have gone to court. And in all the judgments, in all the cases, the judgments have followed the same angle, that you cannot discriminate against one's right to education on grounds of religion. It has been consistent. And so we needn't have gone to court. If our institutions were strong, I indicate, GES should have stood its ground and insisted that its directive be complied with. But unfortunately, GES became powerless. The lesson is that for other African countries, as we pursue SDG 4, to ensure that every child of school-going age is able to enroll and complete the full course of basic and secondary education, our education systems must begin to embrace the concept of inclusion sufficiently and without necessarily resorting to the law courts to settle matters that can actually be, settled around the table. At one key cardinal principle of a society that is growing, a democratic society for that matter, is its ability to resolve issues, without necessarily litigating over same. And so I would implore other countries to not to follow this example. I wish we would have settled this matter out of court. But for now, once the matter is settled, let's support the children to enjoy their right to education because they are already late. It's almost it's past 1 month in school, and we wish them well.
Great. Peter, is the Institute for Education Studies going to be monitoring how they fare in school?
That would be an interesting thing to do. We think that
unfortunately, I think that connection is frozen, but pretty much I think we've exhausted this conversation. So Kofi Asare, I appreciate your time. Thank you very much. Peter Nti, thank you so much for your time as well. We had Bright Apia and Martin Pable also join us on this very intriguing conversation about two children really with dreadlocks. They are Rastafarians. It's not that they didn't qualify. They actually qualified and were placed by the computerized school placement system to Achimota School. And they opted to be day students, except that the school decided not to admit them because of their type of hair. The court has now ruled and settled it. Is this the end, or there will be an appeal? My guests don't seem to think that there's likely going to be an appeal, but we also worry about the kind of atmosphere at Achimota School, the school that they're finally going to settle in. So we will keep monitoring how it goes, and we will update you on this matter.